Wolfsdorf. I'm the managing partner of the Wolfsdorf Rosenthal immigration law firm. I am making this presentation today, this brief, short update for human resources and HR employers in the United States. The Immigration Reform and Control Act of 1986 requires that all employers in the United States complete Form I-9 within 3 days of hire for all persons employed in the US. This form is the I-9 form. The government has recently made some changes and asked for some suggestions in regard to updating the I-9 form, and I want to talk to you about the suggestions and updates, which are 3 fairly complex points, but perhaps would be relevant and useful for you. The first and most important is the completion of the Form I-9 for remote hires. One of the problems with the I-9 is that the employer must verify that they have seen the documents authorizing the person to be employed, which is either a document showing the identity of the individual and the right to be employed, or 2 separate documents, one verifying identity and the other verifying the right to be employed. So for the first time, the US is now clarifying that when you hire somebody in a remote location, for example, your head office could be in New York, but you're hiring someone to perform services in Los Angeles. And the question then is, how do you verify that you've seen the documents, the actual real documents? And you're not allowed to use Skype or FaceTime, so you have to actually look and see at the document. So the USCIS is in the process of updating the form and will give guidance to the effect that one can appoint an authorized agent. That could be a notary, that could be a lawyer, or quite frankly, it could be any responsible person who will certify that they've seen the document. So thank you for that helpful resolution. It's only, gosh, my math's not that good, 30 years later that they've finally given some clarification on how to resolve the remote employee hiring situation. The second is a small one, but when you complete the section 2 of this form, again, one needs to present what we call a column A document, such as a passport, and that passport, obviously US passport, would show your right to be employed in the US, and it also discloses your identity. Fairly straightforward. But if you do not have what they call a column A document, then you have to complete a column B document, which is an identity document, such as a state-issued driver's license, and a column C document, which authorizes your right to be employed. The government has also clarified that one should not put in the initials or the letters N/A for not applicable. They have given us better guidance on what type of documents need to be presented, clarifying, for example, that the employment authorization document, the EAD, that is a column A document, and column C, which relates to the catch-all category of employment authorization, would not include a column A document such as an EAD. This is fairly complex, but the clarification that we've received is nevertheless very, very helpful. In a nutshell, if you have questions regarding the I-9 form, please feel free to reach out. We can be reached via email. My email is my name, bernard@wolfsdorf.com. We can also be reached by telephone, 1-800-VISA-LAW, VISALAW. Thank you so much, and I hope this helpful tip on the new I-9 proposal will help you comply with U.S. immigration law.